is if I have to take this letter into court as evidence, will it contain all the necessary elements I need to substantiate my position? Okay, so let's get into it. Okay, and it starts off by saying, Dear Mr. Doe, I'm writing in response to a dunning letter received from your organization dated 01/01/2017 regarding an alleged debt in the amount of $1,100. My records indicate that you received tender of payment in satisfaction of this alleged obligation on 02/03/2017 as verified by my receipt of U.S. Postal Form 3811 sent via certified mail, and then you have the number. Return receipt requested. Nothing in your correspondence indicates that my tender has been dishonored subsequent to an attempt to presentment. In the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect or impossibility, I'm attaching a copy of the same presentment to this notice of default and opportunity to cure. Please send confirmation that the account has been adjusted and settled, or a notice of dishonor from a qualified third party to allow me an opportunity to cure any defects. If you have an excuse for not performing as requested, please mail your particular statement to me at the address above. Your specific performance or statement is expected no later than 10 days from the date of this letter postmark. Thank you for giving this matter your immediate time and attention. Failure to cure the breach will result in a presumption that all statements in my initial correspondence have been adopted and agreed to by your organization. Okay, and that's what you want. You want a one-page letter. You want it concise. That is a skill you want to develop. You want to develop getting everything you need to say on one page. Okay, you don't want to have, pages and pages of letters where you're breaking down codes and all of this kind of stuff right here. It's not for you to provide them all that information. Okay, you just need to establish something, because first of all, your attitude when you receive something like that back at first is that they're testing you, or they made a mistake. And we're going to talk about mistake in just a second, because that is a principle of law contained in the UCC, what a mistake is. All right. So we got 4 paragraphs. And in this first paragraph, we contain you're basically giving them an overview or reminding them of everything that you have submitted to them so far. You got your proof of your certified mail, which is your 3811 form. And this is what a 3811 form looks like. Okay, it's a green card. On the 3811 form on the back, I always put my own address. I always have the green card sent back to me because I don't want the notary to lose it. But that is up to your discretion. You can have it sent back to the notary or yourself. But I'm going to make sure I have that green card. And that green card in court is going to be presented as evidence. You're going to have that as an exhibit in evidence if there is a court proceeding. All right, as well as your affidavit of mailing, which is over here. Your affidavit of mailing is should be an original, because you need to put originals in court. So I always make 2 affidavit of mailings. I have the notary do an original one for them, and I have a notary do an original one for me. I always have 2 originals because I put originals in court. You also want to get your affidavit of mailings authenticated. You go down to the courthouse where the notary received her commission, and you have the clerks authenticated. It's only about $10. Well, at least it is in Georgia. I don't know how much it costs in your jurisdiction, but it's usually not something that very expensive to do. And so you have authenticated documents prepared to go into a court if necessary. Okay. Now, I want to talk real quick about the form of this particular letter. Notice I always put my certified mailing up in the heading. You just click up here and you put that in the heading. That makes sure that it appears on all subsequent documents in your correspondence. I actually got this from an attorney, the way he did it. And I started doing that from this point on. Also in my footer, I'm always going to put my page count, and it's always going to be page 1 of something. Okay, and I always do that, make sure that that is inclusive of my affidavit of mailing. All right, to let it know that all this goes together. It also helps you keep your records in order too, because you know what pages go with what. So things don't get mixed up. It makes it very, very easy for you to do that. Okay, and I'm always putting a notice to agent is notice to principal. Notice to principal is notice to agent. You can do that by inserting a box in here in Word. Just go here and insert a text box. Click on the first one, and you can insert it in here like this. All right. You put whatever you want in there. All right. And then you simply right click on it, format shape, go to no fill, and then line color, no line, and it'll make the line disappear. And then that way you can move it wherever you want to move it to. All right. But right here, so you can see right here, I can move this wherever I want to move it to. Anywhere on the page. It's not moving. Oh, there it goes. Yeah. So you can just move it. All right. All right. All right. Okay. Make sure you always have your date on there. Date is important. Some people forget to put dates on their correspondence, and always put what it's regarding on there too. And make sure this also is included down in the footer as well. Okay. Now, let's talk about in the second paragraph where it says, in the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect or impossibility. Okay. And it should be unintentional due to reasonable neglect, and it should be mistake. Or impossibility. Okay. Reasonable neglect, mistake, or impossibility. And this is the word I want to concentrate on right here for a second. All right, because all of these are going to be included in the UCC. Okay. All of these are included in the UCC. And we're going to talk about each one of those right now because, as I said earlier, your attitude when you first receive a correspondence, you don't get mad or anything like that. They do things like that to try to invoke some sort of emotional reaction out of you. Okay, yours should be, you should be stoic and just, and like, okay, there must be some sort of error because you didn't send it back. You haven't followed any of the procedures in commerce as it relates to the processing negotiable instruments. There has to be a presentment. Okay, presentment. All right, which is right here. There has to be a presentment. So let's look at each one of those right now. Okay, first stop, we're going to stop at UCC 1-103, which is construction of Uniform Commercial Code to promote its purpose and policies. Applicability of supplemental principles of law. Okay, these are the principles of law. They're principles of law. Remember, principles are few, methods are many. Okay, and the UCC is supplemented with principles of law. Okay, and it'll tell you how those principles are applied. So right here in A, it says the Uniform Commercial Code must be liberally construed and applied to promote its underlying purpose and policies, which are, number one, to simplify, clarify, and modernize the law governing commercial transactions. Number two, to permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. And number three, to make uniform the laws among the various jurisdictions. And here in B, this is what we're looking for next as it relates to mistake. You can see these principles applied as well. And B states, unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. All right, so right here you can see mistake. All right, mistake, coercion, disrupt, all of these apply. Okay, so mistake is a principle of law. Let's take a little time to look up the definition of mistake. And here we are in Black's Law 8th edition. I pulled out the definition of mistake. It is a noun, and in the first sense, an error, misconception, or misunderstanding, an erroneous belief. See error. Number two, contracts. The situation in which either, number one, the parties to a contract did not mean the same thing, or number two, at least one party had a belief that did not correspond to the facts or law. Okay, as a result, the contract may be voidable. And then we have some expert commentary. In this restatement, the word mistake is used to refer to an erroneous belief. A party's erroneous belief is therefore said to be a mistake of that party. The belief need not be an articulated one, and a party may have a belief as to a fact when he merely makes an assumption with respect to it without being aware of alternatives. The word mistake is not used here, as it is sometimes used in common speech to refer to an improvident act, including the making of a contract that is the result of such an erroneous belief. This usage is avoided here for the sake of clarity and consistency. Furthermore, the erroneous belief must relate to the facts as they exist at the time of the making of the contract. A party's prediction or judgment as to events to occur in the future, even if erroneous, is not a mistake as the word is defined here. An erroneous belief as to the contents or effect of a writing that expresses the agreement is, however, a mistake. Mistake alone, in this sense, is not which the word is used here, has no legal consequence. The legal consequences of mistake in connection with the creation of a contractual liability are determined by substantive rules. And this restatement second of contract, subsection 151. And then we have another expert commentary. The word mistake is generally used in the law of contracts to refer to an erroneous belief, a belief that is not in accord with the facts. To avoid confusion, it should not be used, as it sometimes is in common speech, to refer to an improvident act, such as making of a contract that results from such an erroneous belief. Nor should it be used, as it is sometimes is by courts and writers, to refer to what is more properly called a misunderstanding, a situation in which two parties attach different meanings to their language. All right, and so they're going to give you some guidelines on the use of this word mistake and its application. So right here, you can see that this word mistake is something that is a principle of law, and you should account for that possibility that there could be a mistake in your correspondence, and that should be reflected in your correspondence when you're writing them. Okay, was this the possibility of a mistake or misunderstanding or something to that effect? You're giving them an opportunity to clarify their position and to correct any errors that they have made. Okay, the next word we're going to look at is presentment. Now, presentment has two meanings. This is a word you really got to, study and so forth and be aware of, okay, of what a presentment is. And we're going to look at that next in the UCC. But you should be familiar with the commercial meaning of presentment because it does have a different sense that is not commercially related. And you can see, number one, the act of presenting or laying before a court or other tribunal a formal statement about a matter to be dealt with legally. And number two, as it relates to criminal procedure, a formal written accusation returned by a grand jury on its own initiative without a prosecutor's previous indictment request. Presentments are obsolete in federal court. And that would make a very good discussion because the Constitution tells you that they have to make presentment, but they've made it obsolete. That ought to tell you something too. And right here it says, a grand jury has only two functions, either to indict or to return a no bill. The Constitution speaks also of a presentment, but this is a term with a distinct historical meaning now not well understood. I don't understand why they put but. I mean, you see how they tried to get around it? I was just telling you it's in the Constitution, but we don't understand it. It's in there. It says it has to be by presentment. It said historically presentment was the process by which a grand jury initiated an independent investigation and asked that a charge be drawn to cover the facts should they constitute a crime. With United States attorneys now always available to advise grand juries, proceedings by presentment is an outmoded practice. Now, that's a real nice way of saying it. They're here to advise grand juries, or would it be more truthful to say they are directing and controlling grand juries? But anyway, that is something all Americans need to be paying close attention to. Just my feeling on it. But here's the one we're looking for, the commercial meaning for the word presentment. And usually you'll see that in these definitions, a lot of times the third sense of the word will be the commercial sense. I kind of think this is why you have to ask them something 3 times in court to get to the commercial meaning of something. But that's not neither here or there. I haven't been able to prove that, just been my own observation. But it goes on, it says, a formal production of a negotiable instrument for acceptance or payment, and notes. Okay? Presentment and dishonor occur, for instance, when the holder of a check attempts to cash it at the drawee bank, but payment is refused because the drawer lacks sufficient funds on deposit. The demand for payment is presentment. The bank's refusal to pay is dishonor. Okay, so here right now, we get our definition of presentment. All right? And then we have presentment for acceptance, production of an instrument to the drawee, i.e. bank, acceptor or maker, all right, they bring it back to you, or the maker, for acceptance. This type of presentment may be made any time before maturity, except that with bills payable at sight, after demand, or after sight, presentment must be made within a reasonable time. Okay? So here are all these words for presentment, all right? And as you can see, that they had to present it for payment. So, somebody just can't, you give them an instrument and they just give it back. I mean, did you go and try to cash it? Did you at least attempt to cash it? And if you couldn't cash it, is there evidence of dishonor? Okay, send me a protest. That's what a protest is for. And let's look at a protest next. Okay, and here we are with a protest. And as you can see, you have different senses of the word again. And here's the first sense: a formal statement or action expressed dissent or disapproval. Under some circumstances, a protest is lodged to preserve a claim or right, and you can pay taxes under protest. A lot of times you don't feel like you have to pay your taxes and you want to take it to tax court or something like that. You can pay it under protest and then take them to court. Okay, and that's what they mean when you're preserving your right or claim. And then number 2 is the one we're looking for. A notary's public written statement that, upon presentment, a negotiable instrument was neither paid nor accepted, also termed initial protest, noting protest. Okay, and this is the reason why you see notaries in the banks. Notaries have always been heavily involved in banking with the presentation of negotiable instruments. So don't act like, well, we got a bank, we're using a notary. That's just something that is unusual or anything. That's a standard practice in banking. Okay, that notaries do protests on negotiable instruments. Okay, noting or initial protest is a memorandum made on a dishonored instrument with the notary's initial date and the amount of noting charges, together with a statement of the cause of dishonor, such as no effects, not advice, or no account. This is done to charge the memory of the notary and should be done on the day of dishonor. Look at no account right here. So they're saying there's no account. Okay, well, you should be receiving a protest from a notary stating as such. This is why you say in your correspondence, right here, when you look right here in your correspondence, it'll tell you, all right? Please send confirmation that the account has been adjusted and settled, or a notice of dishonor from a qualified third party to allow me an opportunity to cure any defects. Okay? That's what you're saying. Some sort of notice of dishonor from the qualified third party that you're telling them is the notary. They have them. They know what you're talking about. This is standard practice. If they said there's no account, if I give you a negotiable instrument and you said there's no account to cash it at, well, send me something formally in the form of a protest stating as such and allow me an opportunity to cure. You have to know the rules. Well, I did this in court, and it worked like a breeze. A lot of people go in court and allow these judges to catch you up and whether there is some value attached to your instrument. That's not for the judge to determine. The judge is supposed to be an unbiased arbiter in a dispute between two opposing parties, and the burden of proof is on he who asserts, not he who denies. All right? So these are adversarial proceedings, and the judge should not be getting involved in it. If you give somebody a negotiable instrument, okay, they need to return it to you with evidence of a defect saying, okay, there was no account, or there were no funds, or insufficient funds, or whatever. But that needs to be documented and given to you, and then you need to be allowed an opportunity to correct that. That's called an opportunity to cure. But if they don't provide you with that and just start to move forward, they're out of order. Know the rules to the game of commerce. Okay, and then we have the third sense of the word, a formal statement, usually in writing, disputing the debt's legality or validity, but agreeing to make payment while reserving the right to recover the amount later. And that was when I talked about taxes. The disputed debt is described under protest. Number 4, a taxpayer's statement to the collecting officer that payment is being made unwillingly because the taxpayer believes the tax to be invalid. I just told you that. International law, a formal communication from one subject of international law to another objecting to conduct or a claim by the latter as violating international law. And then you have it in patents as well, a proceeding in the U.S. Patent and Trademark Office to determine patentability of an invention after a third party has challenged it in a petition. Okay, and those are protests. This is the word protest, all right? So you need to be familiar with protest, what a notice of dishonor is, okay? Now, a real good practice for you to do would be go get a corpus juris secundum in American jurisprudence and go in there and study bills and notes. Bills and notes, if you're dealing with any kind of negotiable instrument, that is a chapter in American jurisprudence and corpus juris secundum that you should have gone over. You will love it. You're going to learn so much from reading those particular books on negotiable instruments. Really, I don't really see a need to go and buy very expensive books sometimes, because you go to the law library, and because a lot of this stuff revolves around case law, okay, where the judges are making determinations on things. You can find all kind of things in the cases, some of which you'll be amazed at some of the stuff that's been published. But you got to go and dig for it and find it. Okay, and we're back on our letter again. All right. So we went over mistake. We've gone over protest and presentment and so forth. All right, now let's go into the UCC and see what the UCC has to say about a lot of this. Okay, and our first stop is in UCC 3-501, where we find presentment. Okay, A, presentment means a demand made by or on behalf of a person entitled to enforce an instrument, 1, to pay the instrument made to the drawee or a party obliged to pay the instrument, or, in the case of a note or accepted draft payable at a bank, to the bank, or number 2, to accept a draft made to the drawee. Okay, that's a presentment. Now B, the following rules are subject to Article 4 agreement of the parties and clearinghouse rules and the like. Okay, so everything about presentment is subject to anything that's in Article 4, because there may be some exceptions and things of that nature. Okay, and you say presentment may be made at the place of payment of the instrument and must be made at the place of payment if the instrument is payable at a bank in the United States. If the instrument is payable at a bank at the United States. May be made by any commercially reasonable means. May be made by any commercially reasonable means. All right, so when we sit here saying in our correspondence, because you should have an instructional letter, a processing letter as a cover letter, telling them to mail it in, or go to their TT&L department, or so forth. And, you know, you'll see this in a lot of instructional letters or processing instructions for negotiable instruments. Okay, there are no rules that say that it has to go through the ABA, that it has to have routing numbers at the bottom of it, and it has to be processed that way. Those are internal regulations, okay? That's their rules. That doesn't have anything to do with the principles of commerce and so forth. It may be made by, presentment may be made by any commercial reasonable means, including an oral, written, or electronic communication, is effective when the demand for payment or acceptance is received by the person to whom presentment is made, and is effective if made to any one of 2 or more makers, acceptors, drawers, or other payees. This is also why you direct them to send it certified mail, so they'll have evidence that it's been accepted if they have it in the mail, because it becomes effective when demand for payment or acceptance is received. Okay? So, upon demand of the person to whom presentment is made, the person making presentment must, number 1, exhibit the instrument. Okay, did they exhibit the instrument? 2, give reasonable identification, and if presentment is made on behalf of another person, reasonable evidence of authority to do so. This is all the stuff the bank is supposed to do. Okay, 3, sign a receipt on the instrument for any payment made, or surrender the instrument if full payment is made. Surrender the instrument if full pay is made. 3, without dishonoring the instrument, the party to whom presentment is made may, 1, okay, and here's their grounds for dishonoring it. Without dishonoring it, okay, they can return the instrument for lack of a necessary endorsement, or 2, refuse payment or acceptance for failure of the presentment to comply with the terms of the instrument, an agreement of the parties, or other applicable law or rule. Okay, and this is what we say, you can turn it to me as evidence of a defect. Okay, this is what you're looking for. Okay, if they're going to return it, give me one of these reasons why it's being returned. Number 4, the party to whom presentment is made may treat presentment as occurring on the next business day after the day of presentment. If the party to whom presentment is made has established a cutoff hour not earlier than 2 p.m. for the receipt and processing of instruments presented for payment or acceptance, and presentment is made after the cutoff hour. And this is standard in banking. Y'all know if you don't get something in the bank before 2, they process it the next day. But here it is. These are your rules, okay, for presentment, okay? Now, let's look at a couple of other things. Let's start looking at dishonor, which is next. Dishonor of an instrument, all right? Dishonor of a note is governed by the following rules. If the note is payable on demand, the note is dishonored if presentment is duly made to the maker and the note is not paid on the day of presentment. 2, if the note is not payable on demand and is payable at or through a bank, or the terms of the note require presentment, the note is dishonored if presentment is duly made and the note is not paid on the day it becomes payable or the day of presentment, whichever is latter. Okay, once again, they have to make presentment and they have to have evidence of that, the evidence of dishonor. Okay, 3, if the note is not payable on demand and paragraph 2 does not apply, the note is dishonored if it is not paid on the day it becomes payable. Okay, these are all the dishonor. And B, dishonor of an unaccepted draft or other than a documentary draft is governed by the following rules. And this up here is for your notes. And you'll see in the United Nations Conference on International Trade Law, they do the same thing. They always do one for promissory notes and they always do one for bills of exchange. All right. If a check is duly presented for payment to the payer bank otherwise than from immediate payment over the counter, the check is dishonored if the payer bank makes timely return of the check or sends timely notice of dishonor or non-payment under Section 4301 or 4302 or becomes accountable for the amount of the check under Section 4302. Okay? 2, if a draft is payable on demand and paragraph 1 does not apply, the draft is dishonored if presented for payment is duly made to the drawee bank and the draft is not paid on the day of presentment. Okay, and 3, if a draft is payable on a date stated in the draft is dishonored if, number 1, presentment for payment is duly made to the drawee and payment is not made on the day the draft becomes payable or the day of presentment, whichever is latter, or 2, presentment for acceptance is duly made before the day the draft becomes payable and the draft is not accepted on the day of presentment. All right, and 4, if a draft is payable on a lapse of a period of time after sight or acceptance, the draft is dishonored if presentment for acceptance is duly made and the draft is not accepted on the day of presentment. All these you'll see that they have to make presentment. And it tells you if it's just been dishonored, here are the reasons for the dishonorment right here. And they have to cite that for you. Give me my reasons why my instrument was dishonored. Okay, C, dishonor of an unaccepted documentary draft occurs according to the rules stated in subsection B2, 3, and 4, except that payment or acceptance may be delayed without dishonor until no later than the close of the 3rd business day of the drawee following the day on which payment or acceptance is required by those paragraphs. They always go by this three-day business rule, 72. You'll always see this rule of 72, okay? 3 is a magic number. Dishonor of an accepted draft is governed by the following rules. 1, if the draft is payable on demand, the draft is dishonored if presented for payment as duly made to the acceptor and the draft is not paid on the day of presentment. And number 2, if the draft is not payable on demand, the draft is dishonored if presentment for payment is duly made to the acceptor and payment is not made on the day it becomes payable or the day of presentment, whichever is later. And I want y'all to think about a second when you're in court, okay, and they give you a presentment in the form of an indictment, okay? You are dishonoring it if you don't follow these rules. You're dishonoring it if you don't follow these rules. You're in dishonor, okay? Number E, in any case in which presentment is otherwise required for dishonor under the section and presentment is excused under section 3504, dishonor occurs without presentment if the instrument is not duly accepted or paid. This is why you keep saying it's accepted. It has to be accepted. Accepted. This is where accepted for value comes from. Acceptance. Acceptance is a commercial term. F, if a draft is dishonored because timely acceptance of the draft was not made and the person entitled to demand acceptance consents to a late acceptance from the time of acceptance the draft is either treated as never having been dishonored, okay? And if that's they can make some rules to accept it later. All right, so right here you can see all of your reasons for dishonor of an instrument. Okay, now let's go to the next part, which is your notice of dishonor. Okay, so that's UCC 3-503. What is a notice of dishonor? The obligation of endorser stated in Section 3415A and the obligation of a drawer stated in Section 3414D may not be enforced unless, number 1, the endorser or drawer is giving notice of dishonor of the instrument complying with this section, or 2, notice of dishonor is excused under Section 3504. They can't enforce anything unless they give you a notice of dishonor, and here's where the excuse is in 504B, okay? Right here, notice of dishonor is excused if, 1, by the terms of the instrument, notice of dishonor is not necessary to enforce obligation of a party to pay the instrument, or 2, the party whose obligation is being enforced, waive notice of dishonor. A waiver of presentment is also a waiver of notice of dishonor. So you need to do one of these two things for them not to have to give you any notice of dishonor. Okay, so that means you may want to put the terms in your instrument, which we do in our correspondence, saying that, hey, if you dishonor this instrument, we'd like to receive a notice back. This is so simple when you read the rules of commerce. It's incredible to me. It's so simple. It's like reading the instructions to a Monopoly game to me. I mean, you know, once you read the rules of the game, it's like you begin to see very clearly what they're supposed to do. And then that also will let you see when you go back and read these court cases, like when vapor money theories and things, you see what the judge is doing, how he's out of order. They're under the judge cover for the bank. It's not saying you reading the case law and saying, you know, it's like if you know the rules, you can look and see what they're doing. It's not anybody's opinion about the matter. You just read the rules and you'll see it. All right, so these are the rules right here. Notice of dishonor. Now let's see the excuse, presentment, and notice of dishonor. We just got to read it. Here's all their excuses again. Excused, presentment, and notice of dishonor. Presentment for payment or acceptance of an instrument is excused. Now, if, number 1, the person entitled to present the instrument cannot, with reasonable diligence, make presentment. Remember that what it said, reasonable, remember what we said in our correspondence? Okay. It says, in the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect, mistake, or impossibility. All right? So the person entitled to present the instrument cannot, with reasonable diligence, make presentment. 2, the maker or acceptor has repudiated an obligation to pay the instrument or is dead or is insolvency proceedings. Okay, so if you don't do a full all-out acceptance, if you start arguing about the amount, they don't have to make presentment. This is why I say don't argue in court. Number 3, by the terms of the instrument, presentment is not necessary to enforce the obligation of endorsers or the drawer. Okay, and our terms shouldn't have anything said like that. Number 4, the drawer or endorser whose obligation is being enforced has waived presentment or otherwise has no reason to expect or right to require that the instrument be paid or accepted. Let's read that again. The drawer or endorser whose obligation is being enforced has waived presentment or otherwise has no reason to expect or right to require that the instrument be paid or accepted. Okay, so what reason is that? What reason would I have not to have my instrument expected for it to be paid? If I got a bond on file with the Treasury Department and I've given you some processing instructions to get the credits off of my bond to add to the balance sheet of the bank and settle the account. Or number 5, the drawer instructed the drawee, not to pay or accept the draft, or the drawee was not obligated to the drawer to pay the draft. Okay, now, is the Treasury Department obligated to the drawer? Okay, that is the reason why in your first step of the secured party, you attempt to contract with them privately and you send them notices and so forth. And you send them a bond package and give them 30 days and tell them to send it back if they don't agree to the terms. If they've agreed to the terms, then they have an obligation to do this. Or this is what right here is where you put a stop payment on a check in its first part. B, notice of dishonor is excused if 1, by the terms of the instrument, notice of dishonor is not necessary to enforce the obligation of a party to pay the instrument, or number 2, the party's obligation is being enforced, waive notice of dishonor. I just read all of this. Okay, a waiver of presentment is also a waiver of notice of dishonor. And C, delay in giving notice of dishonor is excused if the delay was caused by circumstances beyond the control of the person giving the notice and the person giving the notice exercised reasonable diligence after the cause of the delay ceased to operate. Once again, this is why you have this in here. I'll read it again. If you have an excuse for not performing as requested, you want them to mail it in. In the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect, mistake, or impossibility, I'm attaching a copy of the same presentment to this notice of default and opportunity to cure. So these are containing principles, and these same principles, that's why you read the beginning of the UCC or what you're seeing in all of these codes right here, these principles in operation. Okay, and the last part is the evidence of dishonor, okay, which would be the protest certificate, evidence of dishonor. The following are admissible as evidence. Admissible as evidence. Remember what I said, when you're doing your process, what? You should be writing everything in a way where you are, have to go to court. The following are evidence, admissible as evidence and create a presumption of dishonor and of any notice of dishonor stated. 1, a document regular in form is provided in subsection B, which purports to be a protest. That's evidence. 2, a purported stamp or writing of the drawee, payer, bank, or presenting bank on and accompanying the instrument stating that acceptance or payment has been refused unless reasons for the refusal are stated and the reasons are not consistent with dishonor. And 3, a book or record of the drawee, payer, bank, or collecting bank kept in the usual course of business, which shows dishonor even if there is no evidence of who made the entry. And this is when you ask them for their books. Here are their reasons for that. These are the evidence they have to have that there was the instrument was dishonored. Ain't nothing else. They can't just write you a letter. Ain't nobody signed it and everything saying we don't take this kind of payment. They can't tell you we only take cash, check, or credit cards. A judge said that to me in court. He said, went in, I said, I'm paying this ticket with a promissory note. He said, I'm sorry, we only take cash, checks, or credit cards. And I responded with, am I to understand that the honorable judge is willfully violating public policy? Ask that question. B, a protest is a certificate of dishonor made by United States consul or vice consul or what? A notary public. We just read that in Black's Law. Or other person authorized to administer oaths by the law of the place where the dishonor occurs. It may be made upon information satisfactory to that person. The protest must identify the instrument and certify either that presentment has been made or, if not, the reason why it was not made. And that the instrument has been dishonored by non-acceptance or non-payment. The protest may also certify that notice of dishonor has been given to some other parties. Okay, so here it is. They have to give you some kind of reason. And it has to be by who? Okay? It has to be by who? A consul, a vice consul, or notary public, or other person authorized to administer oaths by the laws of the place where the dishonor occurred. It has to be verified. Once again, this is very simple. It's like reading Monopoly board games. You need to think of this as a game. You're reading the instructions to the game of Monopoly before you get on the board and start playing the game. Let's look at, and part 6 goes into discharge of the payment. And we're going to talk about that probably in another video. Okay, but back to our particular letter. So now you begin to understand how you want to contain everything you need to say on one page. Okay, one page. All right, just one page. And okay, you don't have to have all of this out, this long drawn out page. When they send something back, you send something back, you should make sure it's certified mail. You make sure you have your page count. You make sure you have your address. The address should be to the notary. All right, the notary's address goes up here. Nothing comes directly to you. Your notary is your third party witness to the transaction. She's witnessing whether that mail went out and whether mail came back in, as well as the post office. You remember, you always have to have 2 witnesses, all right? And in your affidavit of mailing, once again, you want to have the name of your notary, that the notary is not a party to the within transaction. You want to identify all the documents you received in your correspondence. Okay, also, you should have copies of all the previous correspondence. Remember, you sent them in a package. They sent you a letter back. Either it was non-responsive, they ignored it, or said, we don't take this. Okay, you send them a copy of everything you sent them the first time. Okay? You keep copies of everything. All right, and you identify how many pages they were. A total of 11. You always write the number and spell it out and give the numerical. So there's no confusion with numbers. Including all attachments, not including this affidavit of mailing by United States Postal Service, certified mail number, return receipt requested, in a sealed envelope with postage prepaid, properly addressed to Lucifer's Lounge, and put the address of the alleged creditor. And then the notary is going to notarize this. And as I said, you always want to have an original of this because you want to present originals in court, not copies. Signed in blue ink and notarized by the notary. And what I have my notary do is I have the notary put a stamp on it and a seal. I have my notaries do all that with both. I want my notary to have both of those things, a stamp and a seal, not just a stamp. Stamps can be, I can take a stamp and use Adobe Photoshop and put it on anything. But that sealed impression is what you want on there as well. And then you want to authenticate this document. Have all your documents authenticated when they're presented as evidence in court. Okay, and I think that just about does it. This is my short presentation on how to respond to someone after you have tendered an instrument for satisfaction of an obligation and that tender appears to be refused. Okay, the appearance of it. Remember, they will always test you. Everything is a test. All right, peace to the gods. I hope you enjoyed this, and I'm out.